We have understood how important the medical record became in a medical practice. And it is a need of the hour. In my personal experience, my friend, when I argue the matter in court, I personally found that it is a great weapon in the hand of a to defend their claim. Whole case is based on the written evidences, which helps every advocate to speak and convince the court about their good deed. In medical practice, very truly, very honestly, let me tell, my doctors always does their best to save the life of the patient. In matter of who come to him, the first option and first thought in the mind of every doctor is to give best to the intention is very clear to give a life to the patient. Intention is very clear to give relief to the patient. And knowledge, of course, every qualified doctor has got. So with the best of the knowledge, with a good faith, he tries his level best, even if it is a medical mishap in the form of accident happens and patient dies. Believe me, my friend, all the laws are there to protect this. Let it be criminal law, civil law, or medical laws. But it need to be proven that he has acted accordance with the law. Means whatever he has done was brought on a paper. If it is brought on a paper, then no one can trouble this dog. And there the importance of medical record comes. Medical record always has got its own domain of recording everything which you have done or your client has done for the patient. And we all know that all this responsibility in every hospital per se is given to the paramedical staff, the nurses. And that's the reason why lots of flaws comes across during the argument, because these people are not trained that way. And they have is not trained in a proper manner. The things which not need to be documented also be documented. And things which need to be documented is not. And this plays a vital. Let me start with this session with the two important case studies to make you understand how important is it to document something which need to be documented and not document something really not needed. The first case is of ENT surgeon who has posted a patient for peritonsillar abscess, has admitted patient in afternoon 2 o'clock in hospital, thought that on OPD he will do a treatment. Send all investigation to the same hospital pathology lab. 4 o'clock, he received a call from the pathology lab, and nurses also confirmed that all parameter is absolutely normal. Patient's blood report is absolutely within normal limit. Knowing all this, he posted a patient at 5 o'clock for surgery. Medical mishap has happened. Patient died. 7:30, after making all the document, the proper record, police was informed, then for the postmortem. Paper document was given to police authorities. Went to civil surgeon for organizing is there medical negligence or not. Taking in a year when report came against the doctor. I personally went for the bail of this doctor in court, and I was uttered that public prosecutors are for converting bailable section to non. and that is only on the basis of medical record and comment done by this. Now, what happened in this case? The civil surgeon has commented on the basis of medical record, multiple findings, but two findings I really wanted. When fruit was observed, fruit, clear indication of pulmonary edema. Why diuretics, Lasix given after 45? Not that my doctor is not given on time, but problem is with my people that while writing particulars and timing, there could be a mismatch. In hurry, with all what mind they write, and because of that, but law is absolute. They read as it is. So if time and particulars are not matching, definitely be questioned. But another comment was really important to understand. What they said, either investigation not done or not documented. Because what happened in that case, which is a very common phenomena in every hospital, that late evening or next day morning from pathology department, report comes to the nurses and get placed in a file of that particular. So here, the medical mission has happened in 2 hours. So there's no opportunity for nurse to collect the pathology report and put in a file. And no one has thought of that. And they have handed over all medical record to the police officer and which has gone to civil surgeon. So pathology report was not there in a hand of medical experts to comment on. But being a medical expert, being a doctor, they were very clear that my doctor is not going to do any surgery without doing proper investigation. Since investigation was not in the hand of these doctors, doctor thought that it has not been done or not documented. And public prosecutor said the law is absolute. Law says 2 into 2, 4. Means if not done, then it is not done. Not documented does not mean that it is done. And hence, he argued that doctor has proceeded without any proper investigation. And there's high chances that patient may have got some blood disease or some intrinsic disease, which has not been overruled prior to the surgery and leaded to death. So section 304A, which was a bailable section, causing a death without intention, negligent act, having a maximum punishment of 2 years. He was interested in changing that to 304 plain, saying that causing a death without intention, with the knowledge that particular thing can lead to death and non-bailable 10 years. My friend, this was really a deadly scenario situation. Hence, in your to see that every paramedical staffs get trained in respect to the maintaining the record to the extent of mentioning any pathology report they receive, even on a call on IPD paper. The pathology report many of the time always is the property of patient, which goes with the patient after discharge. Then doctor does not have access that what investigation was done. To train your paramedical staff to write everything on IPD paper